And I repeat that I'm very, very proud to be here honouring Dame Roma Mitchell, and nobody but Dame Roma could still have the drawing power to get people out in her name to remember her magnificent career. Let's just remember the main points of her career. Born in 1913, she was educated at St Aloysius College in Adelaide. She was admitted to the legal profession in 1934 by the Supreme Court of South Australia. She is not the first, but the second woman to appear in the Commonwealth Law Reports as Miss Roma Mitchell. In those days, the men just appeared as J. Barwick, but women always appeared as Miss so-and-so. She was the second woman to appear in the pages of the CLRs. She was appointed a Queen's Counsel in 1962, and that was the beginning of the run of firsts that she had in her career. First woman Queen's Counsel. 1965, Judge of the Supreme Court of South Australia. She was the first female judge of a Supreme Court in this country. In 1970, relevant to my life, she became the chair of the Criminal Law Reform Committee of South Australia, and I got to know her in that respect when I was appointed chair of the Australian Law Reform Commission in 1975. She was the chair of a criminal law committee, and Justice Howard Zelling was chair of the Civil Law Committee and the South Australian arrangements, and either of those great judges could have graced the High Court of Australia, but no South Australian, remarkably enough, has ever been appointed to the High Court, though it is said it was offered at the beginning of Federation to Sir Samuel Way, Chief Justice of South Australia, whose portrait hangs in the Banco Court in Adelaide, where I often sat during the circuits of the High Court. In 1979, she became chair of the Parole Board, having retired, and she retired from the Supreme Court in 1983. She became chair of the Human Rights Commission of the Commonwealth, the first chair of that and first woman to be a chair. 1982, she was created Dame of the Order of the British Empire, and in 1995 to 9, she was the Chancellor of the University of Adelaide, first woman Chancellor in Australia, and in 1991 to 96, she was appointed as the Governor of South Australia, the first woman Governor. So what a fabulous career, and what an amazing person. Most of you in this room will not have had the privilege of knowing her personally, but I did know her personally. She was strong, she was feisty, she was her own person, she was a leader, she accepted the leadership role, but she never forgot that it was and is, in some respects, harder for women. And there are impediments and disadvantages, not only in the profession of law, but also in the content of law, which has been described as mimicking the man's brain wiring. And Roma was a leader in the legal profession and a great judge and a first in every way, in so many activities. When I used to sit in Adelaide, I always asked if I could sit in her old chambers. They would not have been assigned to me in the order of seniority, because I became ever so senior and ever so high in the pecking order, and I would therefore have been assigned into what I always thought as the men's club, which was in the old building. But she had an anteroom, which was in a sort of an outhouse, you could almost call it, but it was wonderful. It still had some of her furniture. It was the room occupied by Justice Nyland, and Justice Nyland had put in the room, in order to preserve the spirit of Roma in the room, some wonderful black and white photographs of Roma Mitchell as a young silk and as a judge, and I always felt she was there with me. And to take an idea from that magnificent legal text, The Castle, she was the giver of vibes. And I felt the vibes that were there of a strong judge, robust for justice, and strong for the rights of everyone, no exception, equal justice under the law. Now, the task that has been assigned to me today is to talk about the issue of same-sex marriage, which is on the agenda of Australia, and I'm happy to do it. I didn't myself choose it, the Law Institute chose it, but let's go with it, and I'm happy to do so. Selling at the table and quickly selling out, I can hardly see any books left, is this book. It's a masterpiece. It's never been sold so cheaply. It's hardcover. It's a good read, and it's normally $35, but for you, it's $30 for a hardcover book. And it contains a chapter on my partner, Johan, and how I met him, my brilliant opening first lines, which were, and what did you think of Joachim von Ribbentrop? Which David Marr has declared must be the poorest opening lines ever uttered in a love affair that was to last and still going strong for 43 years. Actually, they weren't such bad opening lines, as it turned out, because he was very interested in history. I thought he was a German, and I had done German at school. I still speak German very well. I have ein Sprachgefühl, but he was Dutch, and they don't like being confused with the Germans. They always say, we want our bicycles back. And anyway, he knew von Ribbentrop, and his answer was he was a better champagne salesman than a foreign minister. And I thought, oh, that's an unusual person there. And since that night, the 11th of February 1969, we have been together. And that is a great blessing in my life, and a great blessing in anybody's life, for those who want it. We've learned not to sort of try and force relationships on people. Some people don't want long-term relationships. Some people want them desperately and can't find them. But anyone who wants them and finds them is a very lucky human being. And anyone who would deny another human being such a relationship is really not a very kind person, and they're really formalists, and they've got to be told, well, things have moved on, the caravan has moved on. Now, we're not sure if marriage were available in Australia, we would get married. After all, we've been tested in the furnace of fire with good and bad times, including some bad times. And it's not essential for us personally. But we are both strongly convinced and committed to the notion that for those for whom it is important, who want it, then it ought to be available in a secular country as part of the civil law of that country. And the probabilities are that we would probably edge towards taking the plunge, simply because it would have come about as a result of the efforts of many people who have been struggling for marriage equality. And therefore, it's not a personal thing. It's a question of, in part, legal principle, and it's in part justice for all citizens of this fair country. Now, this is not a political rally. This is a group mostly of lawyers And therefore it's appropriate to remember what's been happening in this matter throughout the world, because it's really a remarkable change that's come upon the face of the law. In 1995, there was a very interesting case in the Supreme Court of Canada, a case called Egan against Canada, in which partners to a same-sex union sought to have their union turned into a marriage by making an application to the local marriage register, and they contended that the definition in the Canadian Marriage Act of spouse was in itself gender neutral and therefore able to be adapted by the courts to their situation. And they wanted it for certain benefits that were available under the Old Age Pensions Act in Canada. And so they went up to the court, armed with the charter. They went to the Supreme Court, and they contended that they were entitled, contrary to the decision of the registrar, to be married. And the Supreme Court of Canada, in one of those exquisite decisions, divided 4-4-1. They are a court of 9. 4 justices, Justice Laforêt, Justice Lemaire, Justice Gontier and Justice Major, held that the primary definition of spouse did not encompass same-sex couples, because the primary purpose of marriage was the bearing of children, and that therefore they fell outside the definition in the Act. 4 of the justices, including 2 of the women judges, the only women judges on the court at the time, Justice McLaughlin, now CJC, Chief Justice of Canada, Justice L'Heureux-Dubé, Justice Corey and Justice Iacobucci, held to the contrary, that spouse was wide enough and that in the spirit of the Charter it should be available to a same-sex couple. Justice Sapinka held the balance of power. I sometimes had that balance of power, not often enough. But Justice Sapinka said, well, I can see the arguments on one side, see the arguments on the other, but we should leave it to Parliament for a while to see if Parliament will fix it up. And therefore, the applicants failed, but they didn't really fail on the argumentation, because it was clear that the majority were moving in that direction. Armed by that decision, a lesbian couple in New Zealand in 1998 went to the local marriage register in New Zealand and asked for the registrar to issue a marriage licence to them. The registrar, in a flurry, didn't know quite what to do, but ended up by refusing. And that was challenged in the courts, and it went to the Court of Appeal of New Zealand, a very strong court, presided over by Sir Ivor Richardson, with Justice Sir Kenneth Keith, now a judge of the International Court of Justice, and other great judges in New Zealand, and Justice now Sir Edmund Thomas. And that court was asked 2 questions. Is it possible to interpret the word person in the Marriage Act as meaning a person of either sex? And if it's not, is that inconsistent with the Bill of Rights Act, which had been enacted in New Zealand, rather similar to the Charter Act in Victoria? In other words, it didn't give the court the power to strike down an inconsistent statute, but it gave the court the power to draw the inconsistency to the attention of Parliament in the hope and expectation that Parliament would then fix it up. So it went to the Court of Appeal of New Zealand, and the Court of Appeal of New Zealand, by a majority with all judges agreeing on the first question, said no, the Marriage Act in its true intendment applied only to a male and a female. And therefore the first question was answered no. But the second question was, is that discrimination against these citizens of New Zealand? And the majority of the Court of Appeal said no, it's not discrimination because marriage has always been a man and a woman, and therefore they're not being discriminated, it just doesn't apply to them. Justice Thomas wrote a stirring dissent. He said, of course it's discriminatory against them, of course it's against equality that they are being denied. They are citizens too, they want to get married, they have a loving relationship, it's a personal, close and sexual relationship, and therefore to deny it to them is discrimination. I read Quilter soon after it was decided, and I must tell you that when I read it, I thought, poor old Ted Thomas, he's lost his marbles. How can it possibly be discriminatory? It's never been available to same-sex couples, and therefore in his decision he's really gone over the barrier, and that he's wrong and the majority are right. Doesn't that all go to show that in this matter, as in so many matters in the law, and as Dame Roma Mitchell would have known, so many matters in the law, it depends on what stage of the journey you're on when you come to a problem, and what your acquaintance with an issue is, and how long you've thought about it, and what other great minds have thought about it when you come to the problem. If a person like me, then with a relationship of 30 odd years, would reach a view that Justice Thomas had lost his marbles, whereas in fact what he said would now be a generally commonplace stance of the court system.